On bench item 1, WPC 652/2018.
May I please, Your Lordship? So this is the matter which pertains to a firing incident which took place in Dima Hasao district, wherein two persons lost their life and three others were really seriously injured, and number of other injured. Lordship had heard the matter, Your Lordship. But Lordship, I would just like to add two points. Lordship.
Yes, Malad. I have placed Subhe Singh and 2 check করেন চেক করে প্রিন্ট আউট থেকে আনার ব্যবস্থা করা but in Subhe Singh, Lordship may I have indicated paragraph. Lordship, I'll yes. But here the case of the petitioner, Lordship, just I'm indicating just before taking your Lordship to my argument, Malad, they have prayed for compensation and investigation. In the an incident took place on (25/1/2018), Malad, and where 2 persons died and 10 persons seriously injured, including brother of the petitioner and the 3 minor. But I have taken your Lordship to paragraph 7 of the petition to indicate what is the case of the petitioner. Just to show the petition of the petitioner, paragraph 7. Their case is excessive use of power by police, and accordingly, they have in paragraph 7 and 8 they said kindly allow me to read paragraph 6 onwards, 2, 3, the projection of the petitioner, that on 25/1/2018, on the eve of Republic Day, conglomeration of various Dimasa people organization call for dharna in various locations of Dima Hasao district against the proposed inclusion of Dima Hasao areas in Greater Nagaland. On the fateful day, that is 25/1/2018, also the protesters had gathered across various locations across the Dima Hasao district and participated in dharna program. It is stated that on the said day, people also gathered in large number in different places across Dima Hasao district, including the railway station. A section of people also sat on the railway track. The program went on peacefully till 2:30 p.m. Be it stated that it was only after the Deputy Commissioner Dima Hasao district who arrived at the spot with a strong police force, without declaring the assembly unlawful, without asking them to disperse, and without using water cannons, rubber bullets, etc. The police started lathi charge without any provocation on the peaceful protesters at Maibong railway station, injuring many women and minors that the protesters and the protesters got agitated. Next, the petitioner begs to state that thereafter the Deputy Commissioner Dima Hasao district, without any warning, ordered for firing, and the police started indiscriminate firing on the unarmed protesters at Maibong railway station with AK series and other automatic rifles, with most of shots taken above the waist, resulting in the death of 2 persons and seriously injuring around 10 others, including the petitioner's brother and 3 minors. The petitioner's father stated that the unprovoked firing on peaceful protesters leading to 2 deaths and nearly dozen injuries from gunshots. Only few hours before the dharna was to end has shaken the entire people of Dima Hasao district. Next method, they said that the petitioners state that the incident of firing at Maibong railway station on 25/1/2018 on the eve of Republic Day is a bolt to our democracy caused by use of excessive force by immature officials with power on their head. So their basic case is, this is excessive use of power. And accordingly, they have prayed. Paragraph 15, accordingly, they have prayed for setting aside and passing the order dated 30/1/2018, bearing memo number so-and-so issued by the district magistrate cum deputy commissioner, ordering for a magisterial inquiry into the firing incident. Setting aside and passing the notice dated 31/1/2018, bearing number so-and-so issued by Ranjit Kumar Losfor, ADC, additional district magistrate, who is entrusted to the magisterial inquiry and to conduct an independent inquiry and/or independent inquiry by a retired judge. And finally, they have prayed for these are the relief prayed. But we have filed affidavit in the matter, and in our affidavit, we have elaborated what has happened. In fact, the first affidavit was filed by the SP, additional SP of Dima Hasao on behalf of the SP. There we have indicated, Lordship may kindly take up the affidavit filed by Indranil Burua on the respondent number 5. Mayank Kumar has filed the affidavit subsequently. Total 3 affidavits we have filed. Indranil Borua's affidavit is first affidavit. Kindly come to affidavit internal page number 2. Para 5. That with regard to the statements made in para 6 and 7 of the writ petition, the deponent begs to state that whereas Dimasa people organizations like so and so, Dimasa Students Union, all Dimasa Students Union, Dimasa Women Society, so and so, called for 12-hour Dima Hasao Band on 25/1/2018 from 5 AM to 5 PM. As stated by the petitioner in para 6, it is stated that on the said date, people gathered in large number in different places across Dima Hasao district, including in railway station. A section of people also sat on railway track. The program went peacefully until around 2:30 PM. In this regard, it is to be clarified that as per police report by memo number so-and-so dated 7/2/2018, at around 9:30 AM on 25/1/2018, Sri Mayank Kumar IPS so-and-so, Maibang reported to SP Dima Hasao through phone that around 400 protesters had blocked the Silchar-bound passenger train at Maibang railway station. Accordingly, additional SP of police headquarters and additional superintendent of police as Dima Hasao were directed to proceed immediately to Maibang with available additional forces with full occupied riot gear. At around 10:30 AM, this doesn't happen at 2:30. In fact, in the morning itself, these are happening. At around 10:30 AM on 25/1/2018, it was learned from SDPO Maibang that the protesters had damaged railway track by removing fish flats of the track and discovered and dislocated several railway tracks. When SDPO Maibang tried to approach them to persuade the protesters started stone pelting on police. So police party waited for crowd to cool down as SDO Civil Maibang refused to declare the assembly as unlawful assembly and use of civil force to disperse the crowd because as per SDO Civil Maibang, safety of onboard passengers of the train did not be ensured if the mob turns violent after use of force. at 10:30. Then it is pertinent to submit that the Honorable so-and-so has declared the Communist Party of so-and-so. Kindly skip that paragraph, kindly come to the next paragraph. That the statements so far it stated that it was only after Deputy Commissioner Dima Hasao district who arrived at the spot with a strong police force without declaring assembly unlawful, without asking them to disperse, and without using water cannon, rubber bullet, etc. The police started lathi charge without any provocation on peaceful protesters. In this regard, a detailed police report by memo number so-and-so was submitted to the Director General of Police. The deponent states that at around 1:30 p.m., both SP and DC, Dima Hasao, reached Maibang railway station as soon as they came out of their vehicle and proceeded towards protesters. The protesters started stone pelting on Deputy Commissioner and SP and other accompanying government officials without any provocations. Thus tried to deter government servant on duty to perform his official works and enforce directions of honorable courts. During stone pelting, several police and civil personnel were grievously injured. They unruly move ahead and damaged several police and civil vehicles and set some hired police Tata Sumo on fire. The unruly mob completely damaged the railway station, building and equipments and attacked GRP establishment at Maibong railway station. And the mob further damaged fuel tank of stern train and had put tire below it with an intention to set it on fire. All these photographs are there, my lord, in the case diary. Immediately, the SDO Civil Maibang declared assembly as unlawful and ordered use of proportionate force to disperse the unlawful assembly from railway station. Accordingly, police used gas grenade, stun grenade, dye markers, rubber bullets, and blank rounds to disperse the unlawful assembly. But the mob still continued with stone pelting and damaging the public and railway property. The police party resorted to blank firing in air. But when situation got worse and stone pelting started from all sides, with no other option left, police party resorted to control single shot firing below knee to disperse the crowd. Look, this I am indicating because the allegation is that they have directly resorted to firing without any warning, without taking any steps. But just to show that before going to firing, they have resorted to the all other means, whatever is available with them. Because after the assembly was called unlawful, they have used the gas grenades, stun grenade, rubber bullets, blank rounds of these things they have done. These measures they have taken. Then, my lord, paragraph 7, we have stated that a ministerial inquiry was ordered by the district magistrate Dima Hasao and also ordered by memo number so-and-so. The one-man committee, my lord, the Home and Political Department, Government of Assam, Sri V.B. Pyarelal, IAS Additional Secretary, to inquire into the incident. Both the reports were submitted. Reports are before your lordship. In the affidavit, we have annexed. But as per the report, there was imminent threat to life and grievous injury to civil and police officials, railway officials, and passengers, and of the train, which culminated into administrative legal action following all legal provisions. Then 2 cases were registered, and paragraph 10 we have said, the case was registered and ultimately 2 FIRs are there, and the investigations were done. In fact, the final reports have been submitted. But in the subsequent affidavit filed by Mayank Kumar, paragraph 4, lordship may kindly see, paragraph 4 of that affidavit. Just indicating at that point of time, the status of investigations where we have indicated, but finally, the final report has been submitted. 2 cases were registered in para 4. The deponent states that, lordship, that part, the para 4, I'm reading, the deponent states that pertaining to the firing incident took place on 25/1/2018, the following 2 cases were registered. A Somoto FIR was registered by police by Maibang PS case number 2 of 18, dated 26/1/2018 under section so-and-so IPC, read with section 3 and 4 of the PDPP Act. The case was endorsed to OC so-and-so. Later, the case was endorsed to the Gaurav Agarwal APS SDPO Lokhipur for independent investigation as per order of the DIGP SR. Invite memo number so and so dated 20/2/18. The case was reimbursed to so and so, and ultimately this is the first case. And second case is a cross case. A cross case by Haflam PS case number 10 of 2018, dated 26/1/2018 under section so and so was registered as per FIR lodged by complainant Sri Kailan Dailavapu of Haflam. As per memo number so and so, dated 13/2/2018 of the Office of the Deputy Inspector General of Police, SR Assam Silchar, the case was endorsed to Gaurav Agarwal. Ultimately, investigations was conducted. At that point of time, the last line we have indicated the cases are pending for further investigation. And finally, these are submitted. Here, Malad, I would like to indicate the inquiry report. The one-man inquiry committee has submitted the report, and the ministerial inquiry report is also here, Malad. At that point of time, in para 5.1, we have said that the inquiry report was, the one-man committee inquiry report was not available with us. Subsequently, in the affidavit, we have annexed the fellow. Here, we have annexed the ministerial inquiry report, para 5, Roman 2. A ministerial inquiry was ordered by the district magistrate Dima Hasav, where ordered as a 31/2018, bearing number so and so, and Ranjit Kumar Loskar ACS, the then additional district magistrate Karimganj district, conducted the inquiry. The inquiry report submitted by memo number so and so, dated 7/2/2018, concluded that the unfortunate incident occurred probably out of provocation made by outside element that did not come into picture, for which police had resorted to use of force to prevent further loss of human life and public properties, and action taken by the authorities seemed to be justified. Kindly come to the report of the magistrate at internal page 44, Annex D. The point logic. Annex D, Malad. Malad. I'll the continuous logic. Logic. Malad. Continue hit on 2/2/2018, the second paragraph of the report. Morning, I have interacted with Sri N.K. Devnath ACS ADM in charge Maibang about the incident that took place on 25/1/2018 at Maibang station. Logic. It is 70. I have taken those. I have taken note. Logic. Here, what the persons have stated, they have he has recorded. Here, Malad, I'll take your lordship to the version of the loco pilot. I'll read, Malad, just version of the loco pilot, goods guard, and the two other officers, Malad. Just starting in the starting, Malad. During interaction, he told me that he has already submitted a report before the Deputy Commissioner Dima Hasav Hapulong narrating the circumstances leading to such incident. He has also furnished a copy of the said report and stated that the said report may be treated as his written statement. During interaction, he categorically mentioned that police officials on different occasions approached him to pass order for dispersing the picketers agitating by using force. Though a prohibitory order under section 144 CRPC prohibiting assembly of 5 or more persons was in force in the district. At that point of time, it was in force. But being an ADM on duty, he gave top priority to the matter of safety and security of all the board passengers, for which he refused to pass such an order, solicited time, and again time and again by the police officers, because police has said that time and again they requested to declare that particular gathering as unlawful assembly. But he said that at the starting point, he did not declare that. Accordingly, he ordered Sri Kumar Gaurav Das, ACS Assistant Commissioner Maibong, to evacuate the onboard passengers with the help of police personnel to a nearby safer place, where foods and other essentials were provided to each and every passengers, including children. Later, the passengers were shifted to Lamding, etc., where situation normalized. He also stated that picketers, protesters damaged railway properties and caused injuries to on-duty police personnel and civil officials. He also stated that he was in constant touch with the district magistrate and apprised the situation time to time. Then I have also recorded the statement of Joynung Haflangbar, PSO attached to NK Devnath. Mayank Kumar is the officer. For the time being, he has filed the affidavit. I'm not reading his statement. Then kindly come to the next page, internal page 3. At bottom, Lordship will find the internal page number. On 5/2/2018, Mrinal Chakraborty, loco pilot, passenger NF Railway Lamding, appeared, and his statement is also recorded. He stated that picketers gathered over the railway track, for which he had to pull the emergency brake at 62/56, 5-6 kilometer before reaching Maibong platform. In the meantime, some picketers threatened to set dire consequences if he did not stop the engine and leave the place immediately. Afterwards, these are not peaceful protests. That is what my endeavor is, that these are not peaceful protests as has been projected in the writ petition. Afterwards, he got down from the engine and contacted with guard, station super, and his highest and his higher ups at Lamding. Meanwhile, his assistant told him that somebody had made a hole to the oil tank and broken the glow rod glass, and oil was leaking heavily, but out of fear he couldn't prevent further leakage. With the help of police help, he ultimately managed the hole partially by using plastic and empty snacks packet, and some people removed the tires which were found below the tank. At around 2 p.m., he left the railway station along with guard after shutting down the engine. He also observed that picketers started stone pelting towards station building and police personnel. Statement he has enclosed. Another, Sri Joydeep Chakraborty, Senior Goods Guard, NF Railway Station, Badarpur, who was on duty with train number so-and-so, also appeared and stated that the train reached the Maibong railway station after crossing all foul marks. Before that, the train had to be stopped at so-and-so kilometer, as some boulders were found stacked over the railway track. However, the loco pilot managed to cross the obstacles. Cattle guard of railway engine partially damaged, and again loco pilot had to stop the train at home signals due to gathering of picketers over the railway track. In the train, there were 14 coaches having around 1,000 plus passengers. His statements also corroborated with the statement given by the loco pilot. He also left the station after consultation with the TT's area officer Badarpur, so-and-so, and loco pilot at around 1:45 p.m. near Breakban. On 6/2/2018, Sri Tulsi Bora, in charge GRP Maibong PP, stated that his staff's strength is limited, and on seeing situation after second warning before arrival of the train, he noticed that suddenly people gathered nearby railway track, throwing boulders over the railway track and placing old used sleepers on the track and blocked the track. Then he informed the OC SDPO Maibong. SDPO OC Maibong is the Mayank Kumar, and the DSP GRP Lamding over mobile phone. Suddenly, ADM Maibong additional SP headquarters reached Maibong railway station and pursued the picketers for dispersal. In the meantime, SS Maibong railway station informed him that some picketers asked him to leave the station and took away the keys of SS room. This is their conduct. After locking the door, he also stated that at around 1:30 p.m., DC sir and SP sir reached Maibong railway station and requested the picketers to call off the rail blockade. Instead, they started shouting slogans and pelting stones. towards police and civil officials, railway building, GRP station, and they have also damaged railway properties and started burning the furniture, other equipments of railways. His statement also corroborated with the statement so far given by the civil police. After observing all this, he said, it transpired from the above observations that there was inadequate police force to tackle with the initially considering the number of picketers, protesters. As a result of protesters, picketers removed the fish plates of the railway track and widened the track of both the front and back side of the strand train. It is also observed that all hell broke loose and an incessant stone pelting erupted immediately after the arrival of district magistrate and the superintendent of police, Dima Hassam. The picketers, protesters started vandalizing and ransacking railway and other public properties, including vehicles of DM and SP Haflong. In my opinion, this unfortunate incident occurred probably out of provocation made by some elements that did not come into picture, for which police has resorted to use of force to prevent further loss of human lives and public properties, and action taken by the authority seems to be justified. So this is his ultimately report. Lordship may consider the statements of the persons who are the railway loco pilot and the railway officials. Even if the police is not believed, the one-man committee report is also there in the affidavit. We have filed another affidavit by Avijit Sinha. From Avijit Sinha, he is the joint secretary to the government. There, the one-man inquiry committee report we have annexed. I'm sorry, I could not collect the serial page numbers. That is why just Lordship. Lordship, I'm obliged. Lordship, I'm obliged. One-man committee report, Lordship. Just look at it. Para 3 of the affidavit, it will be page 85. Para 3. The deponent states that to inquire into the circumstances leading to violence that erupted at Maibong on 25/1/2018, one-man inquiry committee comprising Sri V.P. Pyarelal IAS, the then additional chief secretary to the government of Assam Finance, etc., department was formed by memo number so-and-so dated 29/1/2018. Accordingly, report dated 4/3/2018 was submitted, holding that the decision on the part of the civil and police forces to use force was timely and unavoidable. Due to use of force, including firing, further loss of life and damage of public property was avoided. In short, it was found that there was no lapse on the part of the civil and police administration. Report we have annexed. 87, page 87. He has recorded the incident. Lordship may kindly come to page 88, the second parabola. Hello. he has noted that seeing the situation, the SDO Civil Maibong declared the assembly unlawful and unordered use of proportionate force to disperse the unlawful assembly. Ultimately, the assembly was declared as unlawful. It is their case that assembly was peaceful. It was not declared as unlawful. Without declaring that, force was used. That was their case. That is why I'm indicating. The police used gas grenades, stun grenade, dye markers, rubber bullets, blank round to disperse the crowd, but the crowd continued pelting stones and damaging public property. At that point of time, the police party resorted to firing, which resulted in death of 2 of the agitators and injuring several of them. The situation was then brought under control and the crowd was dispersed. Then finding he recorded. During the hearing, none of the members of the public refuted the fact that the agitators went out of control and public property was damaged. This is important, in my respectful submission. The complaint of the complaint of the people was that the police resorted to firing without giving any announcement or tear gas firing. Secondly, the youth were fired at their head and chest instead of lower part of the body. According to public, this shows that the intention of the police force was to kill the boys rather than to control the crowd. I have gone through all the above arguments and found the following. 1, there was sufficient provocation from the protesters which compelled the district administration to use force by firing, use of tear gas, etc., to control the unruly mob who were indulging in damaging public property and also endangering the lives of the proper officials. Common people and railway passengers, if use of force including firing was not resorted to, casualty in terms of death and injury would have been much higher. 2, it is not a fact that the police did not try other methods like tear gas to control the mob. Police, in fact, used tear gas and stun grenade, etc., to disperse the mob. 3, the boys were hit by bullet on the upper part of the body since the police forces fired from a height, the platform. And he concluded, in conclusion, the decision on the part of the civil and the police forces to use force was timely and unavoidable. I'm stressing on this unavoidable thing, due to the use of force, including firing, further loss of life and damages to public property were avoided. In short, it was found that there was no lapse on the part of the civil and police administration. So this is his report. So, Malad, here before Lordships, Malad, two issues are there, Malad, in my respectful submission. Number 1, compensation, and number 2, investigation. Whether any further investigation is required considering the facts and circumstances of this case, ignoring the report of the ministerial inquiry and the one-man inquiry committee. And the records are available also. The case record, the records which are available, photographs which are available, materials are before in the record, before your lordship. Whether considering all these things, lordship will direct further inquiry by a judicial officer or the judicial inquiry. My humble submission is no judicial inquiry is required because the things are very clear here. The reports are not to be disbelieved in any manner. But yeah, this is my video. Duta said that. Duta said video. More than this. Well, I am placing reliance on these 3 decisions, and I have taken copy of the 3 decisions. One is Subhi Singh that I have already placed, I'll read this judgment again, the relevant paragraphs. And other is 2016-15 SCC 525. That is a decision of Anita Thakur. There, ultimately the law has been laid down by the Honorable Court when the Honorable Supreme Court has said that what is the principle in this type of cases. And third is a case from Gujarat High Court. The Gujarat High Court Division Bench in a similar circumstances, ultimately considering the report of the one-man inquiry committee and the other reports, investigation has been denied. Lordship may kindly, yes, So basically मतलब paragraph 31, 38, 45, 46, 48 and 47. 47 and 48 मतलब. Here excessive power, torture on the part of the police, that has to be before awarding compensation, that has to be established. Compensation as a public law remedy, paragraph 31. In fact, the case of the petitioner is on the basis of the principle of high-handed action on the part of police, and they are seeking compensation. These are in the case of illegal detention and custodial torture, and ultimately the high-handed action on the part of police. When the compensation is claimed, the court has said that the torture has to be proved. Para 31 has it logic got. Though illegal detention and custodial torture were recognized as violation of logic. 1992, মোবাইল দিছিল নহয় বড় বড়টো আছে খুলবা Malo. Para 31 malo. Compensation as a public law remedy. Though illegal detention and custodial torture were recognized as violations of the fundamental right of life and liberty guaranteed under Article 21 to begin with, only the following reliefs were being granted in the writ petitions under Article 32 or 226. A. Direction to set at liberty the person detained if the complaint was one of illegal detention. 2. Direction to the government concerned to hold an inquiry and take action against the officer responsible for the violation. C. If the inquiry or action taken by the department concerned was found to be not satisfactory, to direct an inquiry by an independent agency, usually the Central Bureau of Investigation. Award of compensation as a public law remedy for violation of fundamental rights enshrined in Article 221 of the Constitution, in addition to the private law remedy under the law of torts, was evolved in the last two and a half decades. Kindly, Malad, come to 38, Malad, para 38. All the decisions were discussed in the above paragraphs, and finally, after noting the decisions, Malad, Honorable Court has said, it is thus now settled that the award of compensation against a state is an appropriate and effective remedy for redress of an established infringement of fundamental right under Article 21 by a public servant. The quantum of compensation will, however, depend upon facts and circumstances of each case. Award of such compensation by way of public law remedy will not come in the way of aggrieved person claiming additional compensation. Then kindly come to para 40, whether compensation should be awarded for every violation of Article 21. In MC Mehta versus Union of India, the Constitution bench of this court, while considering the question whether compensation can be awarded in a petition under Article 32, observed thus: we must therefore hold that Article 32 is not powerless to assist a person when he finds that his fundamental right has been violated. He can, in that event, seek remedial assistance under Article 32. The power of the court to grant such remedial relief may include the power to award compensation in appropriate cases. We are deliberately using the word in appropriate cases because we must make it clear that it is not in every case where there is a breach of fundamental right committed by the violators that compensation would be awarded by the court in a petition under Article 32. The infringement of the fundamental right must be gross and patent, that is incontrovertible and expressly glaring, and either such infringement should be on a larger scale affecting the fundamental right of a larger number of persons, or it should appear unjust and unduly harsh or oppressive on account of their poverty and disability or socially or economically disadvantaged position, to require the person or persons affected by such infringement to initiate and pursue action in civil courts. Ordinarily, of course, a petition under Article 32 should not be used as a substitute for enforcement of the right to claim compensation for infringement of a fundamental right through the ordinary process of civil court. It is only in exceptional cases of the nature indicated by us above that compensation may be awarded in a petition under Article 32. If we make a fact analysis of the case where compensation has been awarded by this court, we will find that in all cases, the fact of infringement was patent and incontrovertible, the violation was gross, and its magnitude was such as to shock the conscience of the court, and it would have been gravely unjust to the person whose fundamental right was violated to require him to go to the civil court for claiming compensation. Lordship may kindly come to para 45, Lord. Cases of violations of Article 21 involving custodial death or torture is established or is incontrovertible stand on a different footing when compared to cases where such violation is doubtful or not established. Where there is no independent evidence of custodial torture, or where there is no medical evidence about any injury or disability resulting from custodial torture, nor any mark scar, it may not be prudent to accept claim of human right violation by persons having criminal records in a routine manner for awarding compensation. That may open the floodgates for false claims, either to either to mark to money from the state or as to prevent or thwart further investigation. The court should therefore, while jealously protecting the fundamental rights of those who are illegally detained or subjected to custodial violence, should also stand guard against false, motivated, and frivolous claims in the interest of the society and to enable the police to discharge their duties fearlessly and effectively. While custodial torture is not infrequent, it should be borne in mind that every arrest or detention does not lead to custodial torture. Well, ultimately, while granting compensation, the principle will be same. It is the high-handed action on the part of the police, either in the case of the custodial torture or in the case of, as in the present case, the principle will be same. They are alleging excessive use of power by the police. Then kindly come to para 47. We should not, however, be understood as holding that harassment and custodial violence is not serious or worthy, and where there is no medical report or physical marks or independent evidence, we are conscious of the fact that independent evidence or proved by marks of scars, every illegal detention, irrespective of its duration, and every custodial violence, irrespective of its degree of or magnitude, is outright condemnable and as per se actionable. Remedy for such violation is available in civil law and criminal law. Public law remedy is additionally available where the conditions mentioned in the earlier paragraphs are satisfied. We may also note that this court had softened the degree of proof required in criminal prosecution relating to such matters. So ultimately the ratio in my humble submission is that the high-handed action or the illegal action on the part of the police for awarding compensation under public law remedy, that some proof has to be there. It has to be proved. In the present case, it is because of the violators, the agitators' action. Ultimately, the police had to take the action. Though both the reports says, okay. Therefore, this compensation and the investigation thing, it doesn't come, in my humble submission. Lordship may take the Gujarat case. Let me please the Supreme Court case first. The Anita Thapa, 2016, 15 SCC 525. This is a case where compensation has been granted, but the law has been reiterated. What is to be seen? How? What are the principles for granting compensation, if at all it has to be given? For facts, paragraph 7, kindly come to paragraph 7. On 7/8/2007, the following events, paragraph, there is some, I'll just indicate while reading. Otherwise, para 7 to 10, some paragraphs are there. 11 to 11, 12, I'll read, and 13 also. Little bit of facts are required. I'll just placing. On 7/8/2007, the following events occurred. 1. At about 1 p.m. on this day, 3 petitioners, all members of Jammu Kashmir National so-and-so, arrived at Katra to speak with the authorities concerned regarding plight of the migrants. The petitioners conducted a 1-hour-long discussion with the Deputy Commissioner so-and-so and Tahsildar. The migrants resumed their peaceful march and the petitioners joined the march to ensure that there was no undue harassment by police. At about 2 p.m., 500 armed policemen blocked the bridge that the migrants were about to cross and began attacking the marchers with lathis and tear gas shells. Petitioner 2 attempted to approach the police, which included respondent number 6 to 9 to stop the attack, and was attacked into custody after being brutally assaulted and having his leg broken. He stayed in police custody without medical aid till 9 p.m. when he was taken first to Katra Government Hospital, then shifted to Government Medical Hospital, Jammu at 11:30 p.m. Petitioner number 1 then attempted to approach the police to secure medical aid for the injured migrants. As soon as she entered the police control zone, she was violently attacked by several policewomen, dragged on the ground for a long distance, and put into police jeep. Petitioner was beaten inside the jeep and also at the police station. Petitioner number 3 was also arrested for trying to cover the incident. The petitioner para 8, the petitioner number 1 was admitted to Government Medical College Hospital, Jammu on 8/8/2007. Copies of medical reports of petitioner number 1 have been filed by the petitioners. Bar Association of Jammu and Kashmir also started protest against the aforesaid criminal assault on petitioner number 2 by abstaining from courts on 9/8/2007. Petitioner number 2 and 3 were released on interim bail by the judicial magistrate. Then petitioners filed contempt case alleging violations of court ordered so and so. Then kindly come to para 10. Here is a case where after the excessive power used by police, they were the agitators were in the custody of police. Even after that, police overpowered and they tortured. In that case, considering that amount, the compensation has been granted. Just here, principles were laid down. That is why I'm referring this. Para 10, the respondents have appeared and denied the version of the petitioners. The official version which has surfaced on record in the form of response into the various averments made in the writ petition is that about 500 migrants on 1/8/2007 blocked the Resai Poni Road near Baradari, bringing the entire traffic on standstill. Dharna continued the entire day and night, and the unruly crowd damaged the police vehicle. Leaders of the Panthers party in discussions with the administration agreed to leave the Dharna. However, they backtracked and the Dharna continued. On 2/8/2007, the protesters started marching towards Katra. Administration at Sula Park requested them to go back. All offers of relief were turned down. On 3/8/2007, high officials of the state reached Servad and persuade the crowd to adopt a realistic and pragmatic approach. Suggestions of providing ration and cash relief for 3 months on a par with border migrants were given. Migrants initially agreed to it, and it was decided to gather the Agar Jito temple when the ration shall be distributed on the same day. However, the migrants later refused and an offer and demanded cash relief on a par with the Kashmiri migrants. High officials camped at Servad on 3/8/2007, 4/8/2007 to persuade the migrants. On 5/8/7 and 6/8/2007, negotiations continued. Directions were given to provide facilities of water, medicine, food, along with milk packets for infants. Some of the demonstrators accepted the relief of the government. However, insofar as the petitioners are concerned, instead of amicably sorting out the issue, they raised new demand for providing for at least areas for last 40 months. Police authorities informed the migrants that the competent authority shall be informed and that they should return peacefully and not march ahead to disturb the ongoing Amarnath and Vaishno-Devi Yatris. The agitators, protesters, however, took strategic positions alongside the road and started pelting stones on the police personnel who were trying to initiate dialogues. Few of them even used their lathis, which they were carrying. The crowd marched towards Balni Bridge, where the police contingent reorganized. However, the demonstrators had turned violent and wanted to proceed to Katra. Keeping in view the security and in face of no other option, police resorted to mild lathicharge to control the move. The injured migrants and the police were taken to PHA Katra, 17 police and this is the version. Then it became clear from the above that both the parties are accusing each other. At the time of hearing, the counsel for the parties stuck to their respective stands. In support of their version, even CDs containing videos of the incident were placed. Kindly come to next paragraph. We can appreciate that holding peaceful demonstration in order to air the grievances and to see that their voice is heard in relevant quarters is a right of the people. Such a right can be traced to the fundamental freedom that is guaranteed under Article 19(1)(a). 91B and 91C of the Constitution. Article 91A confers freedom of speech, and this is discussed. We can skip for the time being, my lord. Then after that, it hardly needs elaboration that a distinguishing feature of any democracy is the space offered for legitimate dissent. One cherished and valuable aspect of political life in India is a tradition to express grievances through direct action or peaceful protest, organized non-violent protest march, where a key weapon is the struggle for independence, and the right to peaceful protest is now recognized as a fundamental right in the Constitution. Notwithstanding above, it is also to be borne in mind that the aforesaid rights are subject to reasonable restrictions in the interest of the sovereignty and integrity of India, as well as public order. It is for this reason the state authorities may It is for this reason the state authorities many times designate particular areas and routes, dedicating them for the purpose of holding peaceful meetings. On the other hand, there is always a possibility of a public rally may become unruly, which can mean damage to life and property. This is when public assembly becomes unlawful, which is defined in section 141 of the Penal Code 1860. Under these circumstances, the district administration and the police are permitted to disperse the crowd to prevent injuries or damages. This may entail the use of force in a controlled and specified manner. We also have section 268 IPC, which defines public nuisance as any act which must necessarily cause injury, obstruction, danger, or annoyance to persons who may have occasion to use any public right. Further, section 143 CRPC empowers an executive magistrate to prohibit the repetition or continuation of public nuisance, and section 144 CRPC permits issuance of direction to members of the public to abstain from a certain act or to take certain other order with respect to certain property in his possession or under his management. Thus, next paragraph, thus, while on the one hand, citizens are guaranteed fundamental rights of speech, right to assemble for the purpose of carrying peaceful protest, possession, and rights of free movement, on the other hand, reasonable restrictions on such right can be put by law. Provisions of IPC and CRPC discussed above are in the form of statutory provisions giving powers to the state to ensure that such public assemblies, protests, dharnas, or marches are peaceful and they do not become unlawful. At the same time, while exercising such power, the authorities are supposed to act within the limits of law and cannot indulge in excesses. How legal power should be used to disperse the unruly crowd has been succinctly put by the Punjab and Haryana High Court in Honorable High Court in Karam Singh versus so-and-so, wherein High Court has held that 3 prerequisites must be satisfied before a magistrate can order for use of force to disperse crowd. First, there should be an unlawful assembly with the object of committing violence, or an assembly of 5 or more persons likely to cause disturbance of the public peace. Secondly, an executive magistrate should order the assembly to disperse. Third, in spite of such orders, people do not move away. These principles are similar. This has to be followed. Before adverting to the instant case in hand, we would like to make some general remarks about the manner in which these demonstrations are taking shape. Recent happenings show an unfortunate trend where such demonstrations and protesters are on increase. There are all kinds of protests on social issue, political issue, and on demands of various sections of the society and varied kinds. It also becoming a common ground of religious, ethnic, regional, language, caste, and class divisions are frequently exploited to foment violence whenever mass demonstrations or dharnas, etc. take place. It is unfortunate that so and so that then, my lord, the Honorable Court has put stress, my lord, that in para 16 towards the end. Thus, on the other hand, the maintaining law and order is a important facet, my lord. That does, on the other hand, law and order needs to be resorted, and at the same time, it is also to be ensured that unnecessary force or force beyond what is absolutely essential is not used. So the the principle is the use of force, use of force, whether the use of force is reasonable in that particular event or not, that lordship will see. That is the principle. Ultimately, in this present case, paragraph 18 or honorable court has recorded that it was a control move, and those persons who were ultimately injured, they were within police under police custody, so they should not have done that. And accordingly, compensation has been granted. But I'm on the principle of law. My respectful submission is that use of force to maintain law and order is permissible. And the three principles which the honorable court has noted, that has to be seen, whether those steps have been taken by the police or not before using force. In this particular case, ultimately, amount has been paragraph 19. Amount has been relief has been awarded. Some compensation has been granted. Considering paragraph 18. Then lordship may kindly take up. Therefore, para 18, when we examine the present matter in the aforesaid conflictors, we find that initially it was the petitioner protesters who took the law into their hands by turning their peaceful agitation into a violent one, and in the process becoming unruly and pelting stones at the police. On the other hand, even the police personnel continued to use force beyond limits after they had controlled the move. In the process, they continued their lathi charge. They continued to beat up all the three petitioners even after overpowering them. They had virtually apprehended these petitioners, making them immobile. However, their attack on these petitioners continued even thereafter when it was not at all needed. As far as injuries suffered by these petitioners are concerned, such a situation could clearly be avoided. It is apparent to that extent that respondents misuse their power. So, to that extent, fundamental right of the petitioners due to police access has been violated. In such circumstances, in exercise of its power under Article 32 of the Constitution, this court can award compensation to the petitioners. That is the clear-cut finding in that particular case, considering the entire facts and circumstances that police has used excessive power. So, misuse of power has to be proved. That is my whole endeavor. That misuse of power by police has to be proved, has to be shown. If that misuse is not there, after as in the present case, there the question of compensation doesn't come. Investigation and compensation will not come. Lordship, I'll take your lordship to the third case, from Gujarat, It was a case of riot, my lord. Para 11 to 15, kindly, I'll straightway take your lordship to para 11 to 15. This is the case of the petitioner, my lord. The para 11, we have heard learned advocate Sri so-and-so who has submitted that the incident in question had resulted into death of 4 persons and injuries to 3 persons. It has been submitted by Sri so-and-so that the police ought not to have resorted to firing, as it was possible for the police officers to control the assembly before it became unruly. It has been submitted by him that had the police remained more vigilant and active, they could have controlled the mob around 8 a.m. Kindly come to para 18, 11 of Bhailal Bhai Vital Das Gantra. Para 11. This is para 11 to 15 is the case of the petitioner. We have heard the learned advocate so-and-so who submitted that the incident in question had resulted into death of 4 persons and injuries to 3 persons. It has been submitted that by Sri so-and-so that police ought not to have resorted to firing, as it was possible for the police officers to control the assembly before it became unruly. It has been submitted by him that had the police remained more vigilant and active, they could have controlled the mob around 8 a.m. On 18/7/97, when there was hardly 500 to 700 persons in the mob, it has been submitted by him that the police personnel were conscious of the fact that the mob was likely to become unruly and was likely to create some difficulties or problems, and yet they miserably failed in controlling the mob right from the beginning. He has thereafter submitted that the police has exceeded its authority while using the force and while resorting to tiring. It has been submitted by him that police manual and provisions of section 129, 130 of the CRPC deal with manner in which preventive measures are to be taken by police authorities for the purpose of dispersing assembly by use of civil force and use of armed forces. The manner in which firing is to be resorted is also stated in rule so-and-so of the police manual. It has been submitted by Sri so-and-so that the above referred provisions of CRPC and the police manual are not strictly followed by the police personnel, and therefore the concerned policeman should be held liable for the atrocious police firing. He has submitted that the persons who lost their lives were hit by bullets on the upper half of their bodies. It has been submitted by Sri so-and-so that normally whenever firing is resorted to, an effort is made to prevent the mob from becoming unruly and to disperse the mob. Intention of the police should never be to kill members of the mob. In the instant case, learned advocate so-and-so has submitted that instead of resorting to firing in the manner prescribed by the police manual, the concerned policeman had made a positive effort to kill members of the mob by aiming upper portion of their bodies. Learned advocate Sri Patel has submitted that the police ought not to have resorted to firing, and even if it had become a must, they ought to have aimed lower limbs, that is leg or feet of the members of the mob. But instead of doing so, an effort has been made to kill members of the mob, or the police had acted in an absolutely rash and irresponsible manner. In the above referred circumstances, Sri Patel has prayed that the entire incident should be inquired into by an independent judicial officer. He has submitted that an inquiry, if made by a judicial officer, would be absolutely impartial and would not do any favor to any miscreants. It has also been submitted by Sri Patel that even the report of the additional district magistrate reveals that force used by police while controlling the unruly mob was in excess of what was actually required, and relevant provisions of the police manual are not strictly followed. Sri Patel has concluded with a prayer that some guidelines should be provided by this court so as to see so such an untoward incident is not repealed in future. He submitted that there are several other methods of control unruly moves, and instead of resorting to firing, the police personnel should have used other methods. It was also suggested by him that the state of Gujarat should think of having some alternative method to control unruly moves so that the police might not be constrained to resort to firing with normally takes lives of Scrabble persons. It was clarified by Sri So that it was not his prayer to direct any inquiry under provisions of the Commission of Inquiry Act 1952. Then from 17 onwards, the respondent's contention. No permission was granted to convey any meeting or to have any rally or a procession in Kesod on 18/7/97. On the contrary, rallies and protesters had been banned by the police authorities, and in spite of the said fact, around 500 to 700 persons had gathered near Sarda Shop on 18/7/1997. Kindly, Lordship, take a note that here also in our case, an order was there. That's violating that order, they gathered. Speeches were delivered by politicians so as to instigate people present at Sharda Show. The leaders and members of the assembly speeches were delivered by politicians so as to instigate people present at Sharda Show. The leaders and members of the assembly wanted to submit a memorandum to the Mamlatdar Keshor, and therefore it was decided by them to proceed towards the office of the Mamlatdar. As organizing rally or procession was banned, the concerned police inspector and the executive magistrate Keshor had repeatedly requested the persons present there not to organize rally. But ignoring the instructions given by the said officers, the rally was formed, and gradually more and more people had joined the said rally. Ultimately, when the rally had proceeded towards the cloth market, Ambavadi, Raj Cinema, and Station Road, the strength of the rally had increased to approximately 7,000. When the rally had reached Churcho, members of the mob or the rally started raising slogans against Dr. Ambedkar and started throwing stones at a statue of late Dr. Ambedkar. Within some time, the mob became violent and made an attempt to damage Siddharth STD PCO. And ultimately, the said cabin shop named Siddharth So-and-so was set on fire. And also an effort was made to set on fire Sri So-and-so. In the above referred to circumstances, several warnings were given by the police personnel present there and by the executive magistrate Keshor, but as the said warning had not resulted into dispersal of the mob, the police had to resort to lathi charge. In spite of sufficient warnings and lathi charge, when the mob had not dispersed, around 9:45 a.m., tear gas shells had to be fired after giving sufficient warning. As a result of firing of the tear gas shells, the mob had become more unruly and started pelting stones at police personnel who were on duty. In the above referred to circumstances, the police had given sufficient warning to members of the unlawful assembly, and as the move took no heed of the warnings, the police had resorted to firing in air upon orders given by the executive magistrate, who was personally present. As firing in air proved to be ineffective, the police personnel had to fire at the members of the mob so as to see that the mob is dispersed, and ultimately the incident with regard to the police firing had taken place. It has been stated by the additional district magistrate in his report that due efforts were made by the concerned police personnel and the executive magistrate to see that the unlawful assembly is dispersed, sufficient warnings were given, lathi charge were resorted to, and tear gas shells were fired. Before having effective firing, a few rounds were fired in air, and as well as the above referred to measures miserably failed, the police had to resort to firing, which ultimately resulted into death of 4 persons and injury to 3 persons. In the report, it has been submitted by the additional district magistrate that while resorting to firing, certain provisions mentioned in Gujarat Police Manual Volume 3 were not strictly followed by the police personnel, and therefore he has come to the conclusion that some irregularities were committed at the time when the firing was resorted. However, looking to the overall situation prevailing at the relevant time, the additional district magistrate has come to a positive finding that it was absolutely necessary to resort to firing so as to control and disperse the violent mob, and therefore firing was duly justified. Here also, the report says that it was unavoidable. It has also been suggested by the additional district magistrate in his report that our armed police force should be given due training so as to see that high firing can be resorted and to without resulting to loss into human lives. Even Lanet so-and-so has also submitted that the police authorities of the state Gujarat should have devised. Then Lordship kindly come to para 21. We have carefully gone through the report, and we are also of the view that perhaps after hearing most provocative speeches delivered by the politicians, the mob had become violent and had made efforts to set fire to cabin shop and a human being. The incident took a violent turn into a very short time. The entire crowd was proceeding towards the office of the Mamlatdar for the purpose of submitting a memorandum, but all of a sudden they became violent, and perhaps it was not possible for the police personnel present there to control the mob without resorting to firing. In the circumstances, we are also prima facie of the view that the police was justified in resorting to firing. Then kindly come to para 24 below. Looking to the facts and circumstances of the case, we do not feel that any judicial inquiry should be ordered in the instant case. The purpose of giving direction for holding a judicial inquiry is to gather necessary facts and to find out persons who are responsible for the incident. In the instant case, a comprehensive report has been given by the Additional District Magistrate District Junagadh, wherein he has given a complete detail with regard to the incident and has also come to a particular conclusion. It is now for the state of Gujarat to take appropriate action on the basis of the said report. As all relevant facts have been duly highlighted in the said report, we do not think it necessary to appoint another commission to make further or another inquiry. Giving direction for holding another inquiry would amount to waste of public money. We are, however, sure that the respondent government will look into the report and shall give appropriate direction. So, in that view of the matter, Malon, the ultimately court has said, relying on the fact-finding report of the additional district magistrate, Honorable Court said that no further inquiry is required. And para 26, Malon, in view of the facts stated herein, and in view of the report submitted by the additional district magistrate, we do not think that this court should interfere in the matter. However, sure that the respondent government would look into the matter and take appropriate measures in person to this so-and-so, and with regard to the amount of compensation to be paid to the heirs of the deceased and those who are injured, we direct the government to take an appropriate decision about the quantum of compensation to be paid. Here also, some amount has been already paid to them. Some amount has been in interim has been paid. So serial number করা আছে পেজ, serial number করা আছে পেজ গুলো, নাম্বারিং করা আছে। কতজন জেলে যাবে? কতটা জেলে যাবে? আরো কতজন? কত আছে? কত কি দুটো আছে? SP वर just now बोलता है मालूम है SP वर SP वर तो मालूम SP टेलीफोन और खाना और पत्थर मारिए तो पत्थर पूले तो मालूम मोई बोला पूले तो ये भी से ना ना पत्थर का पूले ये तो क्लियर होने तो दिया से ना तो दिया से पेज नंबर पर आते और चेक कर सकते क्या कर सकते रिकॉर्ड कर सकते तो मतलब referring to the records. और क्लास violators cannot be now becoming a second C conversion. मतलब taking back your lordship to the records. मतलब the photographs which are available in the records at page 190 we have presented it at page 196 if it is available with your lordship you should case that is of the two police cases we have submitted. I'm giving. I'll check. I believe I have we have given. Even then I'll check. From page 196 to onwards, these are the photographs. This photograph shows what was the situation at that point of time. And see the Yeah. So the eleven কেটে আসলে 6, 11, 25 ওটা খোলা আছে। আপনি যদি আছেন এতে দিবেন যদি আছেন লজিক But I can hand over the hard copy, the copy of which I have. I have this, I have taken soft copy. The soft copy of the report I have. So, the taking your lordship to the records, my respectful submission is the photographs which are available in the record shows that the situation there, the magnitude of the situation, and ultimately whatever is available in the report, those are the evidences are there. In fact, the photographs are evidences. Tires were accumulated. The rail, the stations, vehicles, those are destroyed, and stone pelting, all these things are there. Therefore, in my respectful submission, the incident, the action on the part of the agitators, the report of the magisterial inquiry report and the one-man inquiry report and the law, as it stands today, but it suggests that the action of the police on that day, it was unavoidable, and the police has taken the action to stop them. Otherwise, the magnitude of the injury, the loss would have been more. Therefore, my humble submission is the investigation as sought by the petitioners is not called for in this case. And also the persons who got injuries, this is subject to, I leave it to your lordship, because of their own act, they sustained the injuries. So therefore, the compensation is also not, in fact, some amount has been paid, and I would submit that they are not entitled for any compensation also. So the prayer, therefore, made in this writ petition do not deserve consideration by the Honorable Court. This is my humble submission. And one order of the Honorable Court that I'll refer, 6/11/2025. This is a vital aspect. This kindly consider this aspect also. The two cases were registered. 6/11/2025, Lordship has observed. Lordship, yes. Yes, my lord. One is FR, one is charge sheet, and whatever they have remedy, my lord. If someone is agreed, some persons are agreed, my lord, they have the remedy. They can avail that remedy also. The final report, charge sheet is also provided with is available before Lordship. So this is my humble submission, Lord.
Lordship, earlier I had submitted a written submission, Your Lordship, and a compilation. And I agree with my learned friend, Your Lordship, that there are two issues, Your Lordship. One is in regard to an independent inquiry, which we are seeking. And secondly is in regard to the issue of compensation. Now, in regard to the judicial inquiry or an independent inquiry that we are seeking, Your Lordship, I would like to submit one judgment of the Honorable Apex Court in regard to two factors, Your Lordship. One is in regard to the credence of a magisterial inquiry. And the second is, Your Lordship, the right to know the truth, the doctrine of the right to know the truth, Your Lordship. So I'll just place the judgment of the. This is a judgment in the Extrajudicial Victim Family and Association versus Union of India. Citation is 2016, 14 SLC 578 within bracket 2. Lordship, I'm relying on para 84, 85, 86, 253, 254, 257.1. Lordship, if I may just read the paragraphs here, Lordship. Para 84, 85, 86, 253, 254, 257.1. The judgment was delivered by Justice Lokur. This writ petition under Article 32 of the Constitution raises important and fundamental questions of human rights violations, not in the context of the accused, but in the context of the victims. Do the next of kin of deceased victims have any rights at all, other than receipt of monetary compensation? Next paragraph. The allegations made in the writ petition concerns what are described as fake encounters or extrajudicial execution said to have been carried out. Lordship, have it? I'm on para 85, Lordship. The allegations made in the writ petition concern what are described as fake encounters or extrajudicial execution said to have been carried out by Manipur police and the armed forces of the Union, including the army. According to the police and security forces, the encounters are genuine and the victims were militants or terrorists or insurgents killed in counterinsurgency or anti-terrorist operations. Whether the allegations are completely or partially true or entirely rubbish, and whether the encounter is genuine or not is yet to be determined. But in any case, there is a need to know the truth. The right to know the truth has gained increasing importance over the years. This right was articulated by the United Nations High Commissioner for Human Rights in the 62nd session of the Human Rights Commission. In a study on the right to the truth, it was stated in para 8 that though the right had its origins in enforced disappearances, it has gradually extended to include extrajudicial executions. This paragraph reads as follows, quote, with the emergence of the practice of enforced disappearances in the 1970s, the concept of the right to the truth because the object of increasing attention from international and regional human rights bodies and special procedures mandate holders. In particular, the ad hoc working group on human rights in Chile, the working group on enforced or involuntary disappearances, and the Inter-American Commission on Human Rights developed an important doctrine on this right with regard to the crime of enforced disappearances. These mechanisms initially based the legal source for the right upon Article 32 and 33 of the additional protocol to the Geneva Conventions of 12/8/1949. Commentators have taken the same approach. However, although this right was initially referred to solely within the context of enforced disappearances, it has been gradually extended to other serious human rights violations, such as extrajudicial executions and torture. The Human Rights Committee has urged a state party to the International Covenant on Civil and Political Rights to guarantee that the victims of human rights violation know the truth with respect to the acts committed and know who the perpetrators of such acts were. India is a signatory to this convention, Your Lordship. It is necessary to know the truth so that law is tempered with justice. The exercise for knowing the truth mandates ascertaining whether fake encounters or extrajudicial executions have taken place, and if so, who are the perpetrators of the human rights violation, and how can the next of kin be commiserate with, and further steps ought to be taken, if any. Lordship will now come to para 253, Your Lordship. It's at page third last page of the judgment of the order. Para 253. Lordship have it. Insofar as holding a magisterial inquiry is concerned, NHRC has stated in their affidavits that the guidelines issued from time to time are not being followed in the true spirit. That apart, NHRC has complained that the state government, within bracket, including perhaps the state of Manipur, invariably take more than reasonable time to submit important documents such as a post-mortem report, inquest report, and the ballistic expert report, as well as the magisterial inquiry report. Therefore, it appears that the magisterial inquiry is not given its due importance. But in any event, since it is an administrative inquiry, which is apparently conducted in a casual manner and not a judicial inquiry, not much credence can be attached to the magisterial inquiry report. In this context, it may also be mentioned that NHRC has also complained about the poor quality of the magisterial inquiry reports received by it, and it is pointed out that in some instances, the family of the person killed is not examined, nor is any independent witness examined by the magistrate. That being the position, it is not possible to attach any importance to the magisterial inquiry conducted at the behest of the state government, even though it might have been conducted under Section 176 CRPC. Therefore, we make it clear that even if the state government decides to hold magisterial inquiries and take suitable action on the report given, it would not preclude any other inquiry or investigation in the allegation made. in situation of the kind that we are dealing with, there can be no substitute for a judicial inquiry or an inquiry by NHRC or an inquiry under the Commissions of Inquiry Act 1952. There are a lot of similarities with our case and what has been observed, Your Lordship. There has been, Your Lordship has noted when Your Lordship had perused the case diary, that the post-mortem report was not even available for nearly 7 years, Your Lordship. It was collected after 7 years, Your Lordship. Ballistic report was not available. There are a number of lacunas, Your Lordship, which were there. Victims' family statements were not taken. Victim statements were not taken, Your Lordship. Lordship will come to 257.1, next page, Your Lordship. Of the 62 cases that the petitioners have documented, their representative and the learned amicus will prepare a simple tabular statement indicating whether in each case a judicial inquiry or an inquiry by NHRC or an inquiry under the Commissions of Inquiry Act 1952 has been held, and the result of the inquiry and whether any first information report or complaint or petition has been filed by the next of kin of the deceased. We request NHRC to render assistance to the learned amicus in this regard. We make it clear that since a magisterial inquiry is not a judicial inquiry, and as mentioned above, it is not possible to attach any importance to the magisterial inquiries, the tabular statement will not include magisterial inquiries, Your Lordship. This is our observation of the apex court, and this is the credence of, Your Lordship, a magisterial inquiry. In our case, the magisterial inquiry was submitted only after 2 weeks, Your Lordship. It was submitted on 7th of February. Incident happened on 25th of January. Lordship, I'm relying on, before I quickly summarize on the facts, Your Lordship, I will place another judgment of this Honorable Court, Division Bench of this Honorable Court regarding compensation, Your Lordship. (2017) 3 GLR 282. The facts are at paragraph 3, Your Lordship. I'll quickly read. Facts in short are these. Bapon Roy was married to Baby Roy on 30/9/2012. At that time, he was a young man, aged about 32 years, and was also serving as science teacher in a private English medium school at Silchar. His trouble started from 11/6/2013 when wife Bobby Roy lodged a report against him at Lakhipur police station for an offense under section 498A of the Indian Penal Code. On 11/6/2013 itself, the investigating officer of the case, Assistant Sub-Inspector of Police Biman Dev, arrested Bapon Roy from his house and brought him to Lakhipur police station. He was then remanded to judicial custody on 12/6/2013 and sent to Central Jail, Silchar. And from jail, he was taken to Silchar Medical College Hospital on 13/6/2013, where he was declared brought dead by the doctors. The dead body of Bapon Roy was handed over to Badal Roy on 14/6/2013 after it was subjected to postmortem examination. According to the postmortem examination, report dated 15/6/2013, his cause of death was due to organophosphorus insecticide poison. Lordship, the paragraph I am relying on, Your Lordship, starts from paragraph 8, Your Lordship. Paragraph 8, 9, 10, 11, 12, 13, and 14. Lordship, will kindly take up paragraph 8. The liability of the state to pay compensation for deprivation of the fundamental right of life and personal liberty is a new liability in public law created by the Constitution, not vicarious liability or a liability in tort. For this reason, this new liability is not hedged in by the limitations, including the doctrine of sovereign immunity, which ordinarily apply to states' liability in tort. This view is strongly supported by the decision of the Privy Council in Maharaj versus Attorney General of Trinidad and Tobago, 1978 2 ALL ER 670. Section 1 of the Constitution of Trinidad and Tobago recognize, amongst others, the right of the individual of life, liberty, security of person, and the right not to be deprived thereof, except by due process of law. Any person alleging contravention of this right and other human rights and freedoms recognized under Section 1 and 2 can apply under Section 6 for redress to the High Court, which is empowered to issue appropriate orders, writs, and directions for enforcement or securing the protection of provisions of the aforesaid sections. The appellant in the case was a barrister and was committed to 7 days imprisonment by a judge of the High Court, which committal was set aside by the Privy Council in appeal on the ground. The particulars of the specific nature of the contempt were not told to the appellant, and the judge had thereby failed to observe a fundamental rule of natural justice. The appellant had in the meantime applied for redress under Section 6 on the ground that he was deprived of his liberty with due process of law. This application was dismissed by the High Court, but appellant again came up in appeal to the Privy Council. The Privy Council held that Section 6 of the Constitution impliedly allowed the High Court to award compensation, as that may be the only practicable form of redress in some cases. The Privy Council also held that as the appellant's committal was in violation of the rules of natural justice, he was deprived of his liberty without due process of law in contravention of Section 1 of the Constitution and was entitled to claim compensation from the state under Section 66 thereof. In meeting the argument that a judge cannot be made personally liable for anything done or purporting to be done in exercise or purported exercise of his judicial functions, Lord Diplock, speaking for the majority, observed, quote, "The claim for redress under Section within bracket 1 for what has been done by a judge is a claim against the state for which what has been done in the exercise of judicial power of the state. This is not a vicarious liability. It is liability of the state itself. It is not a liability in tort at all. It is a liability in public law of the state, not of the judge, which has been created by Section 6 within bracket 1 and within bracket 2 of the Constitution." As to the measure of compensation, Lord Diplock said, "The claim is not a claim in private law for damages for the tort of false imprisonment, under which the damages recoverable are at large and would include damages for loss of reputation. It is a claim in public law for compensation for deprivation of liberty alone. Such compensation would include any loss of earnings consequent on the imprisonment and recompense for the inconvenience and distress suffered by the appellant during his incarceration." Paragraph 9. The above view was accepted by the Supreme Court in Nilabati Behra versus State of Orissa, AIR 1993 SC 1960. In that case, the petitioner's son died as a result of injuries inflicted on him while he was in police custody. A letter sent by the petitioner to the Supreme Court was treated as a petition under Article 32 of the Constitution. The Supreme Court directed the state of Orissa to pay rupees 1,50,000 as compensation to the petitioner. In directing so, Justice J.S. Verma observed, quote, "Award of compensation in a proceeding under Article 32 by this court or by the High Court under Article 226 of the Constitution is a remedy available in public law based on strict liability for contravention of fundamental rights, to which the principle of sovereign immunity does not apply, even though it may be available as a defense in private law in an action based on tort. This is a distinction between the two remedies." Justice Verma further explained that the state's plea of sovereign immunity for tortuous acts of his servants is confined to the sphere of liability in tort, which is distinct from the state's liability for contravention of fundamental rights, to which the doctrine of sovereign immunity has application in the constitutional schemes, and is no defense to the constitutional remedy under Article 32 and 226 of the Constitution, which enables award of compensation for contravention of fundamental rights, when the only practicable mode of enforcement of the fundamental rights can be the award of compensation. Concurring with Justice Verma, Dr. A.S. Anand, Justice A.S. Anand, in the same case observed, "The purpose of the public law is not only to civilize public power, but also to assure the citizens that they live under a legal system which aims to protect their interests and preserve their rights. This court and the High Court, being the protectors of the civil liberties of the citizen, have not only the power and jurisdiction, but also an obligation to grant relief in exercise of its jurisdiction under Article 32 and 226 of the Constitution to the victims or the heir of the victim whose fundamental rights under Article 32 of the Constitution of India are established to have been flagrantly infringed by calling upon the state to repair the damage done by its officers to the fundamental rights of the citizens, notwithstanding the right of the citizens to the remedy by way of a suit or criminal proceedings. The state, of course, has a right to be indemnified by and take such action as may be available to it against the wrongdoer in accordance with law through appropriate proceedings. Justice Anand also observed, there is a great responsibility on the police or prison authorities to ensure that a citizen in his custody is not deprived of their right to life. Next paragraph. The case of Nilabati Behera was followed in D.K. Basu versus State of West Bengal, AIR 1997 SC 610, which lays down general principles relating to custodial death cases. The judgment in this case was delivered by Justice Dr. Anand, who reviewed the earlier authorities. It was reiterated that a relief of compensation against the state based on the principles of strict liability under the public law is one to which the defense of sovereign immunity does not apply. And this relief is in addition to the traditional remedies and the compensation awarded in a given case, it adjusted against any amount awarded to the claimant by way of damages in civil suit. It was also held that in the assessment of compensation under Article 32 or 226, quote, the emphasis has to be on the compensatory and not on the punitive element. The objective is to apply balm to the wounds and not to punish the transgressor or the offender, as awarding appropriate punishment for the offense, irrespective of compensation, must be left to the criminal court in which the offender is persecuted, which the state in law is duty bound to do. Although the cases of Nilabati Behera and D.K. Basu discussed above, which laid the basis for the concept of public law wrong related to violation of Article 21, the observation in them are general, that violation of fundamental rights will be public law wrong redressable under Article 22, 26, and 32. A three-judge bench of the Supreme Court, however, in Hindustan Papers Corporation versus Ananta Bhattacharjee, 2004, 6 SCC 213 has held that the public law remedy for the purpose of grant of compensation can be resorted to only when the fundamental right of a citizen under Article 21 is violated and not otherwise. The court further said that it is not every violation of the provisions of the Constitution or statute which would enable the court to direct grant of compensation. Paragraph 12. Earlier, also in the case of Rudul Shah versus State of Bihar, AIR 1983 SC 1086, which arose on a petition under Article 32 of the Constitution, complaining prolonged detention of the petitioner even after his acquittal, the Supreme Court directed the state to pay rupees 30,000 as interim measure without precluding the petitioner from bringing a suit to recover further damages. The court, while observing the objection that the petitioner should be left entirely to the remedy of a suit and no damages or compensation should be allowed, even as an interim measure, observed, the petitioner can be relegated to the ordinary remedy of a suit if his claim to compensation was factually controversial, in the sense that a civil court may or may not have upheld his claim, but where the court has already found, as in the present case, the petitioner's prolonged detention in prison after his acquittal was wholly unjustified and illegal, there can be no doubt that if the petitioner files a suit to recover damages or for his illegal detention, a degree for damages would have to be passed in that suit. Similarly, in Bhim Singh versus State of J&K, AIR 1980C, SC 494, which was again a case under Article 32 of the Constitution, the Supreme Court directed the state of Jammu and Kashmir to pay rupees 50,000 as compensation to the petitioner who was an MLA and was illegally arrested and detained to prevent him from attending the assembly session. Paragraph 13. A survey of the cases referred above goes to show that it is now well settled the defense of sovereign immunity is not available when a state or its officers acting in the course of employment infringe a person's fundamental right of life and personal liberty as guaranteed by Article 21 of the Constitution. And the state can be directed in a writ jurisdiction under Article 32 and 226 to repair the damage done to the victim by paying appropriate compensation. In the case at hand, as mentioned above, Bapan Roy was aged about 32 years and was newly married. He was arrested on 11/6/2013 for a minor offense under Section 498A of the Indian Penal Code by the police of Police Station Lakhipur, whereafter he was sent to jail on 12/6/2013. And in jail, he died an unnatural death between 12/6/2013 and 13/6/2013. We therefore, considering these facts, direct the state government to pay his complainant father, Badal Roy, compensation of rupees 5 lakh within 2 months from today. We have awarded this amount as compensation, feeling that the amount is just and proper. While doing so, as held by the Supreme Court in the case of D.K. Basu, we have not taken into account the punitive element, as the objective is to apply balm to the wounds of victim's father and not to punish the transgressor. We, however, make it clear that if the father, Badal Roy, feels dissatisfied with the amount awarded, he will be at liberty to resort to traditional remedies, and the compensation awarded in the present case will be adjusted against any amount awarded to him by way of damages in civil suit. In order to unravel the truth regarding unnatural mysterious death of Bapan Roy in jail, and also to prevent similar victimization of prisoners, we direct the District Judge Kachar Silchar to hold an inquiry into the matter and submit a report within 3 months to the Registrar General for information. The District Judge Kachar Silchar shall also submit a copy of report to the Principal Secretary, Government of Assam, Home and Political Department for information and taking appropriate action. Now, Lordship, I will just summarize the facts briefly and the certain distinction from the cases that has been referred by my learned friend. Because in the Gujarat case that my friend has mentioned, Your Lordship, there, Your Lordship, the inquiry was conducted by the additional district magistrate. Here, Your Lordship will kindly see that during the incident, the deputy commissioner was present, the SPO was present, the SDPO was present, Your Lordship. And Your Lordship, there were 3 inquiries which were conducted, Your Lordship. One was, Your Lordship, the SP had submitted a report. Secondly, Your Lordship, there was a one-man inquiry committee, which more or less, Your Lordship, is similar to the SP's report, except in the SP report, it is stated that firing was done in a regulated manner below knee, whereas on the other, Your Lordship, it was saying the boys got injured because the firing was done from the platform. Otherwise, the facts are more or less similar. Magisterial inquiry report, Your Lordship, if Your Lordship goes to the magisterial inquiry report, except for the loco pilots, Your Lordship, the others are all, Your Lordship, from the administration. Your Lordship. There were no statement of the victim's family. There are no statement of the Your Lordship, the victims who survived, Your Lordship. And Lordship, for a moment, will kindly take up the compilation I had submitted earlier, Lordship. Yes. Lordship, will page 1 itself, Your Lordship, is the SP's report, Your Lordship. Lordship will kindly take up the fourth para. At around 9:30 a.m., this is dated 7/2/2018. At around 9:30 a.m. on 25/1/2018. Yes, I have some. Yes. 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 So what I wanted to submit here, Your Lordship, that there are different versions are emerging, Your Lordship. Picture has been given that the mob was violent from the beginning, Your Lordship. But if Your Lordship will see that on one side, there were injury to 13%, 2% died, and others succumbed, 3 were seriously injured. On the other side, if you see, around 11:30 a.m., Your Lordship, nearly 1,000 passengers were taken. There were no injury to any passengers. Even in regard to the police, Your Lordship will see that there was one person was injured and he was let out subsequently. There is a version has been given, that, Your Lordship, around 1:32, the protester attempted to, they punctured your fuel tank and they tried to put tire. This has happened earlier because according to the loco pilot, when the train was coming, Your Lordship, they were blocked by boulders. And through the cattle guard, they removed and they could move ahead. And the loco pilot as well as the guard reported, Your Lordship, that the puncture had taken place. So if anything had to be, any action was to be taken, it had to be taken at that moment. The only version which is emerging from the side of the public, Your Lordship, is from the complaint of Kulenda Dolagapu, Your Lordship. If Your Lordship will kindly take that up, that is at page 20 of my compilation. Because what we are saying is that only after the police started, that was around 1:32 p.m., Your Lordship, then the people got agitated. Otherwise, they were sitting in the railway track. Lordship will come to page 20, Your Lordship. This is Maibang PS case number 6/2018. Gist of the case. On 26/1/2018, at 5:30 p.m., Sri Koilen Dolagapu, President Jadike Neso Hassom Central Committee, Haflong, lodged an Ejahar at Haflong PS, stating that on 25/1/2018, the general public had gathered at Maibang railway station in protest against the proposed inclusion of some parts of Dima Hasao in Greater Nagaland. During peaceful demonstration, some of Assam police used force to stop the demonstration, and the demonstrators got agitated by the police action, and the agitators turned violent with pelting stones, etc. And the Assam police personnel resorted to indiscriminate firing at the demonstration, as a result of which 2 persons were killed and 10 others sustained grievous injuries. Lordship will now kindly see that this is the only version which is emerging, because in the magisterial inquiry, the public, they did not have faith in the magisterial inquiry, they did not participate. But the victim's family and the victim who survived, their statement should have been taken. That is not reflected, Your Lordship. So my prayer, Your Lordship, is that what we are seeking is an independent inquiry, Your Lordship. If their hands are clean, Your Lordship, then why are they shying away from an independent inquiry? Let the truth prevail, Your Lordship. And the second aspect, Your Lordship, will kindly see the duration of the investigation, Your Lordship. 2 cases where there are 9 IOs were changed over a period of 8 years, Your Lordship. It is only after the intervention of this honorable court, Your Lordship, that it started, the case started moving ahead, Your Lordship. The Lordship had called for the reports. Post-mortem reports were not collected. There were discrepancies in the case diaries, Your Lordship. So there is probably an attempt to safeguard the persons who were there, who were from their colleagues in the police or the administration, Your Lordship. So it has been, we have also placed in our additional affidavit in where we have put news reports, Your Lordship, in number of other situations, Your Lordship, in if our additional affidavit, our reply affidavit, Your Lordship, where we have mentioned that in similar incidents in other places, Your Lordship, it is the facts came out only when a judicial inquiry was provided, Your Lordship. When a judicial inquiry went into, for Your Lordship, take up the reply affidavit, Your Lordship, at paragraph 6, we have mentioned. And this is a report from the business standard dated 1/12/2019. A one-member judicial commission headed by a retired judge of Madhya Pradesh High Court to inquire into the firing and killing of 17 villagers and 7 minors from Sarkegoda, Kotagadu, and Rajpenta by a combined team of Lordship. It's at our reply affidavit dated 27/6/2022. Page 6 of the reply affidavit. I'll just read one paragraph, Your Lordship, paragraph 6. We have annexed a few news reports. Paragraph 6, Your Lordship. Page 6, paragraph 6 of the affidavit. That as regard the averments made in paragraph 6 of the affidavit in opposition, the deponent, Lordship, will come to next line. The deponent states that according to a news report in the Business Standard dated 1/12/2019, a one-member judicial commission headed by a retired judge of Madhya Pradesh High Court to inquire into the firing and killing of 17 villagers and 7 minors from Sarkegoda, Kotagadu, and Rajpenta by a combined team of CRPF and police personnel submitted in its report that there was no firing by the villagers and no evidence to prove that they were Naxalites. Be it stated that only because an independent judicial commission was instituted into the said incident by the state government, that it came to light that the police investigation into the incident was manipulated and dishonest, and that there was no evidence to show that any of the deceased or injured villagers was a Naxalite. The deponent further states that according to another news report in the New Indian Express dated 24/5/2018, the state government of Tamil Nadu appointed a retired judge of the Madras High Court to hold the inquiry commission into the police firing at Thoothukudi that claimed 10 lives, and thousands of persons laid siege to the collectorate at Thoothukudi in Tamil Nadu, violating the prohibited order in force under Section 144 CRPC, demanding the immediate closure of the Starlight plant. In another incident reported in the Hindustan Times dated 10/8/2011, Maharashtra government ordered an inquiry by a retired High Court judge into the police firing on farmers by police on a farmers' rally in Pune district protesting laying a water pipeline on their land, wherein 3 people were killed. Be it stated that it is the humble submission deponent and only an independent judicial inquiry by a retired judge of this honorable court will be able to unearth the truth, as any government inquiry is unlikely to be impartial, as high-level officers of police and administration of Dima Hasao districts are involved. The deponent further states that in the King's Bench division by Lord Chief Justice Heward, in a landmark and far-reaching judgment observed, not only must justice be done, it must also be seen to be done. So this is a Lordship, it's a frontier district, Your Lordship, with majority tribal population, sensitive area. The employees of the state is required to be sensitive. When so our submission, Your Lordship, is that there has been high-handedness in the excessive use of power, Your Lordship, in this case instance, leading to the unfortunate loss of 2 lives and injury to number of persons, including the petitioner's brother, Your Lordship. And the investigation was not conducted appropriately. So it is only a judicial inquiry which will unearth the truth. Second aspect, Your Lordship, in regard to, we have been, the deceased, I've got the instruction that deceased were paid around 5 lakhs by the council, Your Lordship. And around 1 lakh was paid to the petitioner's brother, to the 3 injured person. But that, Your Lordship, will not even cover for the medical expenses, Your Lordship, that the petitioner's brother has suffered, Your Lordship. So exemplary compensation and damage should be granted by this honorable court, Your Lordship, to provide relief to the victims who have survived, Your Lordship, and to those who lost their lives in the entire incident. That is my humble submission.
Well, just for a minute, Mulad. But as regard the Badal Roy's case relied by my learned friend for compensation, and that is also relying on the Nilavati Behra's case. Well, the decision which I have placed the Anita Thakur case, Mulad, paragraph 18, the principles were enumerated there. Paragraph 18, the last part, 5 principles were there. And I'm just in reply to that, reading that particular the 5 points towards the end of para 18. Ultimately, after considering the Nilavati Behra also, the court has said, Malad, that the ratio of those precedents can be explained as first, it is clear that a violation of fundamental rights due to police misconduct. Anita Thakur, 2016, 15 SCC 525. Anita Thakur, 18, towards the end. The Nilavati Behra and Saheli Joginder Kaur versus State of Punjab, State of Rajasthan versus Vidyavati, Nilavati Behra, all are they have mentioned. Honorable Court has recorded. Then Court has said held the ratio of these precedents can be explained as also gone. Yes. First, it is clear that a violation of fundamental rights due to police misconduct can give rise to a liability under public law, apart from criminal and tort law. Secondly, that pecuniary compensation can be awarded for such a violation of fundamental rights. Thirdly, it is the state that is held liable, and therefore the compensation is borne by the state and not by the individual police officers found guilty of misconduct. Fourthly, this court has held that the standard of proof required for proving police misconduct, such as brutality, torture, and custodial violation, and for holding the state accountable for the same, is high. It is only for patent and incontrovertible violation of fundamental rights that such remedy can be made available. Honorable Court has held, Mullah. It is only for patent and incontrovertible violation of fundamental rights that such remedy can be made available. Fifthly, the doctrine of sovereign immunity does not apply in cases of fundamental rights violation and hence cannot be used as defense. So, if the fourth principle, Mullah, that for patent and incontrovertible violation of fundamental rights, only the public law compensation under public law remedy can be, which is not a case in this case.
It is in my favor, only, Your Lordship.
It is not
Right
applicable.
to life, Article 2.
Not.
I may appeal also. Yesterday, withdrawn one IM alert for correction of the address alert. Yesterday file IM alert. The matter will be taken up at today itself only for correction of address alert, not more than.
Yes.
May I plead your lordship? Lordship, I beg to mention item number 8, my lord. Probably adjourn for the day, my lord, on this. Next week.
May I please, Your Lordship? Lordship, I beg to mention item number 10, Lordship. Lordship, my senior left the court due to some medical urgency, Lordship.
Lordship, I beg to mention item number 6 of the daily list. There is another writ petition, petition number 1644-23019. That belongs to the father of this petitioner. Lordship, we want both of the matter to be tagged and take along. Same family, same. Lordship. Lordship. Yeah. No, we just want both them to be.
Item 1 for orders. WP Criminal 83/25.
Lordship, may I pray the live proceeding be stalled, Your Lordship? For the time being? একটা অন্য করে ওরকম করা। বাকি কোনো দিন না।
একেই বস্তু দেখুন পয় না এটাই আছে এটাই আছে ফটা সিলটো নাই এটাই বস্তু এটা লইবে আর একটু এটাই আছে ইয়েস করে দিলে এটা আছে 7 hours pera 7 তো সাইকেল করছে
Some people are decent. এখন কি কথা হয়েছে করতে? কোটি বলুক কোটি বলুক ন্যাশনাল নিউজ পেপার tourism. Yes. That's supportable. Yes, which was dismissed, my lord. Learned principles is family court combo. Two contempt cases, your lordship. I'll be giving the number. Yes.
It's 5, 6.
Parvata?
5/26. Very
Parvata?
another times of very.
Yes, by way of mutual divorce. And it was a,
Respondent number 1, namely, Srimati Oshima, OSHIMA, Chaudhary, as well as the minor son of the parties. Next. The learned senior government additional senior government advocate. What may be good? This is me. Additional senior government has produced a copy of the report by the officer in charge of Tigaon Police Station, as well as the officer in charge of Patanjali Police Station. These reports. Interior stating that the mobile phone of the respondent remained switched off and to the call detail records of no concrete clue could be obtained of the respondent and the minor child. Similarly, first one was by Patitioner Police Station. And as per the photo, so it's Patitioner Police Station. Similarly, the officer in charge of Patanjali Police Station has given the details of the steps taken. By stating that it was not available in the permanent address. Her father's address and previous rented addresses at Silpupi and Chanmari. And moreover, the child was not found to be attending the school. And so CDR analysis was carried out to the mobile numbers used by the respondent. None of the said mobile numbers were found active after 12/10/2025. It is also reported that the bank account of the respondent was verified. And it was found that there was no transaction after 24/9/2025. And that no bank account could be found linked to the permanent account number, the income tax permanent account number of the respondent. Accordingly, the said authority has submitted the photograph of the respondent amongst all the officer in charges in the state of Assam. Enable them to trace her out if available in their respective jurisdiction. Next. Photocopy of the said police reports have been provided to the learned senior counsel for the responsible for the petitioner. Next. The learned senior counsel for the petitioner submitted that the investigation of the case be handed over to the CBI. As you want us to record it or you don't record it?
Or CID, your lordship, because the Assam police is unable to.
Because once we reject it.
My lord.
that there, then
Oh, lordship.
cause problem to you.
My lord,
We don't say.
let it be.
for the time being.
My lord may not, right.
I'm saying so because you will be prejudiced.
My lord.
That's fine. We rather write it this way. At this stage, the learned senior counsel for the petitioner has submitted that the petitioner will be allowed to reserve his right to make make a prayer for handing over the investigation to the CID or big CBI.
CID or CID.
He said that being already available, no order of the court is required if this comes. Then next part. View of the nature of investigation and steps taken by the officer in charge of police stations. we observed that despite steps taken by the police, the respondent could not be located. The respondent and the minor son of the parties could not be located. Under these circumstances, how the court is inclined to provide that the I think the cost of the petitioner, the appropriate police authorities would issue a lookout notice for the petitioner, or for the respondent, and the minor child with the petition of the parties. That major railway stations, comma airports, and to also insert newspaper at the lookout notice of the advertisement in which paper?
The Telegraph as well as Times of India.
In Assam, you gave Delhi Assam or some.
Cost will be, my client is saying,
No, because local newspapers, those are more effective. This Procedural and all these are- You can give a short one.
my lord. And one Assamese local newspaper,
Those are more circulated.
My lord.
There is,
nook and corners.
everybody reads that.
অসমীয়া প্ৰতিদিন নাই ন?
Telegraph and Times of India.
See, very digitally through the one.
The police authorities will indicate to the petitioner the cost. He needs to enable the petitioner to make arrangements for the sale. Post office. Yeah, I have music. I have music. Lookout processes at the lookout processes in. Because we have said. This station at airport. Also the. Particular. Electronic media. Electronic media. This is the matter again. Sorry, the let me. Particular registry, sorry, registry. Sorry, it's not found there. Particular registration and particular registration. Let's submit a report. The learned addiction senior government service. Just list again on how much time?
Also,
Is there tell us when you are.
lordship, the second week of February,
Give us a date, we'll fix it on that day.
Madam Coxon,
See, you'll have to take steps.
my lord.
5-7 days.
It will
to take
take
steps,
some
then
time, your lordship. It is on 17th of February,
70,
my lord.
70 to 26. Is where we have missed out anything? No.
No, lordship. But there were, lordship, in bailable warrant of order issued, then no, non-bailable. Thereafter she appeared. Given undertaking before the court, they shall abide by. But and thereafter, the child was handed over by police, my lord. Then, when the mother of the petitioner expired, on 22/9, she has forcibly taken away the child, and from that day, he has gone missing, my lord.
22/9.
Yes, from September.
That because of the orders passed by this court, the minor child was available to the petitioner. However, on
22/9/2025
9/2025.
was forcibly taken away.
The ground that the mother of the respondent had died from the.
No. Mother of the petitioner died.
The mother of
They were under bereavement.
and they were under bereavement. And at that time, the respondent forcibly took away the minor child with her, and since then, the respondent is not in contact with the respondent and the child are
Missing. And she took the help of the lawyer. As such, Honorable Court filed suo motu contempt case. Guwahati High Court contempt case was filed. Not required. Lordship. My lord. My lord.
So that is not relevant. We want to
Lordship.
decide now.
It's a jurisdiction of the special DB. My lord. Obliged.
Very yes. You said to the, what are we said to the court, I will not. It's a difficult word.
My lord.
What about the lawyer?
Notice has been issued. Court directed to file detailed affidavit. Why he has gone to the place of the petitioner and helped. He was like seen in the CCTV footage. He was also there with the lady.
The video was there.
Yes,
it's
yes,
clear.
yes.
Just one.
My lord. We remember something we. Some memories came. Here, said the order like that. My lord.
Normally, if you go and an assist, maybe you can do it at lower cost.
My lord.
Instead of letting the police tell you, you go and tell them that.
Yes, it's my lord, yes.
Then be like that.
In between police will come, then they might charge more.
Those things we are
My lord.
more smarter than us.
Item 2 for hearing.
Right. That if the petitioner remains unrepresented, adverse orders will follow, wait for end of justice, one last chance, one more chance is given to the petitioner to be represented. Very which adverse orders will be passed on the next date of listing, next list on, we date after 2 weeks. Tenth of February.
Item 3 for hearing.
What legal option? Here, your lordship, impugn order, impugn opinion is that page number 91. Here are all together, my lord, 8 petitioners, my lord. They are all family members, my lord. So far, my lord, reference is there, my lord, only against the petitioner number 1, inquiry and reference, my lord.
Sharma, insofar other petitioners are concerned, I think this has to be closed with liberty to the petitioner to make inquiry. So the authorities to make inquiry if required, but this appeal has to be allowed for others.
In prima facie of the case, it appears that Babar Ali, son of late Tamiz Ali, and his family members are suspected to be illegal migrants.
But inquiry was only against one. The forwarding of the police is also by only on against number 1. In the form,
Yes, yes.
last page you see there will be a endorsement. And this is number 1. Please come to this opinion at page 94. Come to paragraph 10.
However, apart from above conclusion, this tribunal proceeded to examine and scrutinize the documents of OP number 1 and testimony of DW4. During evidence, the OP number 1 on his own behalf and on behalf of his family adduced altogether 25 numbers of exhibits.
Correct. Stop here. Now look at the last part of the opinion. The 25 exhibits are not discussed. Look. All the next paragraphs. You can't even know what is dealing with.
Lordship, in this paragraph, Lordship, it was not discussed, but in subsequent paragraph, Lordship.
No, you see only A, B, C, D, then M, K,
Yes,
all 26 documents are not there.
yes,
25 documents are there.
yes, Lord.
Yes, find out 25. At least I don't find it.
Total is come proof common. बाकी एक हो गया
So you have the records.
Yes, Lordship.
Based on case series, find out what are the documents there, how many documents are there in case series. Because you see from this opinion, what are the exhibits we don't know?
Yes, Lord.
How he has dealt with the documents we don't know. The only conclusion is that he has saved a lot of money for the home department. 5 rupees of ink he has saved.
Certificate of Lordship, Gavura.
Many certificates are there.
Yes, Lordship, only family member certificate.
But then what
Enclosed.
is then we can't know because you see, from if 25 documents are there,
Yes.
then A to Y. Now, if there are 6 certificates here, then it will be A to
K1 to
something like
K5, K6, K7.
then something like S, it will come to. Or A to S.
Okay.
In the description. Page 93, you see there's a description. A, B, C, D, K1, K2, K3, K, L, M, N,
Yes,
P,
yes,
Q, R.
Lordship. Yes, Lordship.
Correct. There's something again wrong here. If you come to page 92. On page 92. Here you will find para 4.
Opposite parties have joined together
Opposite parties have
and-
joined file a common statement, so and so paid for dismissal of the so and so. The OP number 1 and OP number 2 examined themselves. And Nurul Islam, OP number 1 by adducing evidence. Correct?
Hmm.
Now, if you turn over to this 94, para 10.
half of one.
Apart from so and so, the tribunal proceed to examine and scrutinize the document OP number 1 and testimony of DW4. Now, DW4 is not mentioned here. DW4 has been examined. Therefore, 2 and 3 has not been examined.
No. Oh,
You've seen it?
not really.
Mr. Sharma, Come to page 60. Very critical. The year is 2004 or 2008? First line.
First line, I think Lordship, this is 2008 because in S column it was written as
This is English.
English.
Okay.
All the numbers are in English.
Mr. Writer, where is your written statement?
My lord, written statement is at page, my lord, 9, annex 9, page 71.
71.
Yes, ma'am.
That's what please.
হেৰি ডিটেইলছ বহুত
কৰিব দিছিলে মানে নামটো কি হৈছিলে মানে 46 নম্বৰ ৰেকৰ্ডত ফটোকপি বাইদেউক এটা দিলো তাৰপিছত আৰু এটা মানে বৰ্মা বাইদেউক দিবলৈ দিছিলে এতিয়া কাৰ কপি অৰ্ডাৰ আপনি একটু মই ৰাখিম আপুনি এটা কৰিব এটা এই অৰ্ডাৰ কপি এটা দি Yes, Mr. Sharma.
Lordship. That Lordship, all exhibited documents are not discussed, Lordship.
We understand, that's what we thought. Not discussed. Whatever we work is not discussed. Evidence of DW 1, 2, 4, that is also
Yes,
only
Lord.
one line, but there's no mention of what was the evidence.
Yes, Lordship.
Have to send it back. And if the police authorities want
Yes,
fresh
Lordship.
inquiry against the other petitioners.
Yes, Lordship.
Need to- It's a letter you'd be agreed, we have not heard you. We require a hearing.
My lord,
We require your hearing.
my lord, what I have to say, my lord, the impugn order, my lord, basically it was passed against the petitioners, my lord, that they have not proved the voter list, my lord. Since it is a public document and the voter list are all certified copy, my lord. This is the only
This
reason.
is not true. On that account, you fail.
Hmm.
The reason is that, you see, we had a very interesting person coming here. He came and told us that this is exhibit 1.
Hmm.
Now, please find out whatever I have made that argument, find out from that book.
Yes, my lord.
He tells us like that.
Yes, my lord.
So what should I do? I ask you a question. That which provision law is applicable? You tell me that, prosecutor, look at this book. It is there, you find it out. That is your answer. So what to do? Because if I start reading this, it will take me at least 2 months to read completely. What should I do? Should I accept your argument?
No,
Then in that the edges are not proved.
exhibit.
And then the tribunal says that when we have proved that in 2008, we have asked you only about one voter's list.
Hmm.
In 2008, there are other persons whom we have not proved. That means it is doubtful. The court does not say it is not proved. It is said it is doubtful.
Please.
What is wrong in that finding?
You have best decision, your lords, who have already not discussed everything, my lord.
Okay. Take it down.
Jesse Koller,
Critic chamber.
Jesse Koller, because
Yeah, critic chamber because of possible time today.
obliged, my lord.
Just think of the name, Mr. K. Letter and this one. And Mr. Sharma, what is the case law that refers not to late against all?
Lordship, Superior.
Superior.
These laws.
Ma'am.
Give this certificate, please.
Yes, sir.
So I can give it to the piece of paper.
Ma'am.
2019 1 GLT 353. 350.
Yeah. You give it a printout of, so was it 19? Was it 19? Give it a printout of, what do you want? One copy.
Para 9. Para 9.
Next.
Item 4 for hearing.
Lordship, Lordship, my name is not there in Wakalatnama. I am appearing on behalf of J. Ahmed. May I proceed? Impugn order, page 30.
At page.
30. 30.
Yes.
Lordship, 1966, page 33. Petitioner father name appear. Page 33. Exhibit D.
Yes.
Page 35. Petitioner stepmother name appear. 1966 voter list.
Yes.
Page 38. Lordship. Exhibit A. The headmaster of Tengaguri MB School issues certificate in favor of the petitioner. 38.
Here the mother name changes. Yes.
Lordship, in 1997, petitioner name appeared along with his father, mother, and brother. Page 45. Serial number 156. Exhibit O.
His grandfather's name is different.
Grandfather name is Kalimuddin Sheikh.
Hmm?
Kalimuddin Sheikh, Lordship. Grandfather.
66.
Lordship.
It's not Kalimuddin Sheikh, it's Kalimuddin.
Lordship.
What is this page 40?
Khalil Sheikh, Kalimuddin Sheikh, Lordship, same person. It's some documents, Khalil Sheikh and Kalimuddin Sheikh.
And what is this page 40?
Lordship.
What is this page 40?
Lal Mia step brother, Lordship. Petitioner father, born and brought up Bihuguri. But after petitioner father got married,
No, you
petitioner
are making things very complicated for us. You said that your own mother's name is
Nami Rohima Khatun,
Mahima Khatun.
Lordship.
page, come to page 40.
Huh.
Lal Mia, you say his brother.
Step brother.
Lal Mia, son of
Johar Ali. Johar
Johar
Ali.
Ali,
Huh.
and Rahima Khatun is the wife of Lal Mia. How can your brother and what you call your brother's wife and your mother can be same?
Okay.
Wrongly written. You should kindly see page 45, 1997 voter list. Rahima, wife of Zaharuddin.
Oh, you see, it's difficult to jump documents.
And 2005 voter list.
We'll show you why we are not inclined to jump documents. Come to page 36. Page 36 is the voter list of 1966.
Lordship.
Jodhab Bibi is 34 years.
Lordship. 38.
38.
Stepmother. Petitioner
It's
stepmother.
okay, whoever she is.
Petitioner mother is second wife.
Now this, what you call this, Jodhab Bibi is missing thereafter.
Lordship, in 1989 voter list, page 42, petitioner stepmother name appeared in the voter list of 1989, page 42, Lordship. Lordship, petitioner father born and brought up
Jawhara Banu.
Behavior.
This is your stepmother, page 42.
Petitioner father got married, petitioner mother.
One. Johura Banu is who? Who is your stepmother? Johar Banu.
Johar Banu.
So you see, are the two villages same, different?
Lordship,
Page 36 is the same village. 36 is, we can't read that.
36, village Behuguri village.
And now here it is. Same village.
Same village. Behuguri.
Now you are showing us 1997.
Lordship, petitioner father got married, petitioner mother and settled down Tulsiguri.
No, your only link document is 1997, correct?
97, 2005.
No,
And-
no, the first document is 1997.
Lordship.
How do you connect? How do you connect the Jahur Ali and Muhammad Jaharuddin is same person?
Same,
And Khalil Sheikh and Kalimuddin is the same person.
same person.
How
Lordship,
do you prove that? How do you show how do you prove that?
Lordship, DW2 Gaura certificate, Gaura also examined, and DW3 Tulsi Mia, step brother, also examined.
What is the name of stepbrother?
Stepbrother name, Lordship. Lal Mia, 1989. Stepbrother, page 14. Tuta Mia, page 43. Stepbrother. Petitioner stepmother and uncle and brother still casting vote Vehuguri. Lordship, in my written statement, page 11, para 5, I clearly stated the father of the opposite party is Johor Ali, but he is known as Johoruddin Johor, and his grandfather is Kalim Sheikh, who is also known as Kalim, Kilon, and Kolil. Written statement, page 11. After second marriage, petitioner father settled down Tulsigori. And Lordship, due to poverty, petitioner father being a daily wages labor, he has moved from place to place in search to work. Therefore, his name did not appear subsequent voter list, Lordship. And finally, in 1997, his name appeared in the voter list of Tulsibari. I clearly stated in written statement, para 11, page 12.
Running here and there,
Lordship,
running here and there. Could not cast vote.
petitioner, 1997, page 45.
I think there is something, I mean, page 12. Can you come to page 12, please?
Page-
Can you come to page 12, please? 12,
Yes.
12, paragraph 12. Okay, where you have stated that, yeah, opposite party have casted vote for the first time in 1997, correct? That
Yes.
you have also submitted. That you have also submitted. Now come to page 13. Come to para 13. You see what you have written there? And subsequently 14 also, 15 also, you see?
The typical mistake, sir. First time.
Every time the person who is starting work, there are different many persons same name, and everybody is starting separate works for the first time.
So it was before the tribunal, and it was never tried to be corrected also.
Kaubra also issue certificate, Lordship. DW3 Tutumia, Lordship. Also examine.
There is a very much problem. See, not frequently you say, after you are married for the second time, you went out from the house and with your other here and there.
Tulsi shifted permanent.
You understand? Something for you to leave the house. Or it won't be able to leave the house. There's no only right you and your this other not a separate proposals. You got anything from the
No. Voter list and Gaura certificates.
করে দিব না। Madam, you were referring to this DW trees evidence, right? DW trees evidence, like you come to page 26. 26. So there might have been some queries from the court, and he replied to the court, right? In the last line, you'll see he left his village Veluguri in the year 1965 to the village Tulsivari, correct?
Yes.
So he left in 65 Veluguri. Now you come to this your voter list of 1966. Page 33. Okay. Yes. So your name appeared in 66 from Velugurian.
Lordship.
So these are contradictory stands, right? They are your own documents, your own witness. You want to prepare more for this case? You want to have a look, have a better look into the case?
Lordship.
You want some time?
Lordship. Can
We can give you some time, provided you come properly prepared.
can
next
you
time.
fix next week?
Okay, we can give you next week. Okay.
Lordship, can you fix February? February first week. Can you fix?
You need some more time. So do some homework. So that you can connect the dots. My lordship was telling.
Yes.
Something from the but you were referring to that. Even if you don't get it answer one, but it would be everything from you. Get it something? Let's bring it. Bring it. Let us why we are referred to that thing. Because I was not there while lots of us referred to that. This came during the middle of the process. And this means don't have to get everything from Dingle. That's it. Do you have any idea why we give that statement to dollars? Dingle is the only selling platform. It gives a envelope where you have to connect the dots. Oh. That is a game it gives. Correct. Yes, every time you have a different credit, you have connect the dots. That's big. Get you from the credit card. That's right things. But here, here is a game. Okay.
Lots.
Yes.
Bless.
Action list item 1, IA Civil 142/26.
Two.
42.
Kopi satu kurusun itu dia semua. Apa satu kurusun?
Oh, bu. Besok ya.
আর একটু আমরা জিনিস ডট সেটা এই হচ্ছে এত রিফ্লেক্ট করবো না অনেক সময় এটা রিফ্লেক্ট হয়ে গেল আমি একটু রিফ্লেক্ট করবো না instant IA has been filed by the petition for correction of the address in the first title for the first title of the writ petition and order dated 18/12/2025 in IA civil in bracket number 4132 stroke 2025. In WBC number also. Yes. In WBC number 8255 stroke 2025. Yes. It is submitted by the learned counsel that inadvertently the address of the petitioner was mentioned as Potia village mentioned as in petition, you right? Village Potia Chapuri, police station Ding, district Nagaon, state Assam, petition complete instead of village Nelly, Dohati Habi, Nelly Dohati Habi, police station Jagirod in bracket Nelly outpost bracket complete, district Morigaon, state Assam, petition complete. In view of next one, in view of the aforesaid inadvertent error in the petition or the order, in the order also the same error the petitioner was allowed to substitute and the correct address. And the same was done by the petitioner. In view of the aforesaid, the first title of first title of the order. In view of the opposite, the instant order shall be read along with the order passed earlier. In view of the passing of the instant order, 10 days time is allowed to the petition to approach the appropriate authority for bail. Appropriate authority.
SP Mori.
So superintendent of police, border Morigaon. For getting for getting bail in terms of the order dated 18/12/2015.
Yes.
According to the instant IA is allowed and disposable. This order should be
Terms and condition earlier passed by the honorable will be same.
It will be read together in terms of the earlier order.
Laws. Deeply on this. I think lordship in repetition, we have to file the. Cost items. We'll file that. That should be replaced. In the main read. 5 to 5. That's it. Okay. Always.
Item 5 for hearing.
Lordship, kindly list the case next week.
Sir, above 21.
Pardon?
The date.
Yes.
Date 21.
Yes.
There is a date 21 years.
Pardon?
Your convenient date?
Eh?
Your convenient date?
Any date, Lordship, on the next date, next week.
29th January.
Yes. Much obliged.
Item 6 for hearing.
My lord, in this case, because of my some personal problem, I could not properly gone through my records, my lord. I have gone through the case record, court record just now, my lord. But I can do. The time is also.
Link ID one is.
Huh?
Link ID.
Not like it. My lord.
17th of February.
Deep love letters.
Item 7 for hearing.
Yes, my lord. Opinion is page 65, my lord. Learned tribunal, my lord, discarded the voter list of 1966 and 70 on the ground that was the certificate copy was not proved through official witness, my lord. By calling the official witness. Official. And petitioner produced the certificate copy. my lord. Yes, my lord. That finding is page 67, my lord. Page 67, second para, my lord. In the middle, my lord. In exhibit A is old and eligible copy of voter list of 1966, where age of parents of OP is not mentioned. And exhibit B, age of Ator Rahman is mentioned as 36 years, and his wife age is 30 years. These exhibits are not duly proved by calling original voter list to ascertain the authenticity.
Even if we omit that for the time being,
My lord.
after this, your parents have just vanished.
Yes, subsequently mother name appeared along with his brother, my lord, but that voter list was not, my lord, exhibited, my lord. And I have annexed here, my lord. But father expired, my lord.
You see, you don't give the death, the year of the death, that's the problem. You merely say your father died.
A date, it, my lord.
Father died is very vague because we are dealing with the issue of citizenship.
In his cross-examination, he stated that he was young as when father was died, my lord. So please, my lord, kindly see. Yes, my lord. This is my lord. Page, my lord. 20. Page 25. Operative, page 25, my lord.
1997,
My lord.
you are Abdul Kalam.
My lord. And my.
Just a moment. Your 66 voters list
My lord.
at page 20,
My lord.
the village is Saro.
Sarokwa.
66.
Sarokwa.
Then
70 also, my lord.
70 also needs
Sarokwa, my lord.
Sarokwa. Yours is 1977.
Yes, my lord.
Now it is a different village. Pilapada.
Kulapara, my lord.
Can you say that person who is in the, whose name appears in the voters list
Yes, my lord.
is connected with you?
In his cross examination, he stated, my lord, I reside in Thelapara and my father is reside in Sarokwa. He is 53, my lord. 53, my lord.
What about this other voter list? This is page 24.
Page 24 is the
You see, Mr. Ahmed, we don't have your family together. That is the problem.
my lord.
You say that you have several brothers and sisters.
Yes, my lord.
Who is the, what is the age of your brothers and sisters? We don't know. Your brothers and sisters also, they don't appear in any of the voters list.
Yes, that voter list is there, my lord. I have a next, my lord.
It shows that
Page 29 is my voter list, my lord. Then my lord, page 27, my lord.
page 27.
And this is voter list of here, my lord. My one brother, my lord, and my mother's name appear, my lord.
So that's what you're saying, that they are not together.
House number is, my lord, my house number is 18 and this house number is 19, my lord. And in the, my lord, 2005 voter list, page 29, my mother name appeared along with me, my lord.
Just now. This is the voters list of 1997.
1997, my lord.
1997. Name of your brother is?
Yes, my lord. Abdul Baten.
Abdul Bater.
My lord. And mother name also there, my lord. Asatun Deva.
No.
And page
Any other voter list?
page 29, my lord. 2005 voter list. My mother name appeared with me, my lord, in my house number 18. Page 30, my lord.
Who is your mother?
Asaton Beva, my lord.
Okay.
Asaton Beva's name appeared in the voter list of 1966 also, my lord.
Then there is no other brother of yours?
And one brother, my lord, appeared before the tribunal as my lord DW2, my lord. Khazamia. He produced some documents on his own, my lord. Voter ID card.
What is his name?
Khazamia, my lord. DW2, my lord.
Which page?
DW2, my lord, page 656, my lord. He also stated my lord Sarokwa. He earlier resided at Sarokwa and my lord subsequently in Thailapara. Page 58 in the close examination. He produced voter ID card, page 60, my lord. And page 61, my lord. My lord, page 18, my lord. Page 18, the revenue receipt, my lord. In the name of my lord petitioner's father, Atar Rahman, and revenue was paid by my brother Khazamia, who was my lord DW2, my lord. Page 18. Of village Sarokwa. This document was proof, my lord, for DW3, my lord. This was, my lord, on 25/11/1969 documents, my lord. Thank you.
What is the district here of this
Gol-
document?
Golpara, Golpara, my lord.
How according to you, this document, this receipt proves anything?
My lord.
How does this receipt prove anything?
Yes, my lord. Page finally similar. DW3, page 61, my lord.
Please?
Page 61, my lord.
Yes.
Suraj Jamal, my lord. He was the, my lord, author of the document. He filed an evidence and he was also cross-examined, my lord.
You have seen the document. Are you aware what the document is?
My lord, land revenue receipt, my lord, by issuing by Jodhar, my lord. Issuing by Jodhar, my lord.
Jodhar doesn't issue it. It is the landlord who issued to the Jodhar.
Hmm.
So your father could not have owned the land.
Yes.
Your statement in the affidavit is false. Your lawyer does not even know what is he dealing with. Will a tenant give a rent receipt to the landlord? No.
No.
Landlord will give it.
Yes.
Now, can you prove that document in evidence? It has to be from the owner of the land. That's one. This is another issue. Although it's not very big because this is a private document, but in 69,
My lord.
people did not use a, what do you call this, ball pen. This is a document which is executed in ball pen.
Ball pen, yes.
That was not at time, those days it was not prevalent.
But
Ball pen started mass use in the year 1972.
Yes. But this is 69.
This is 69. 69 people used to have ink pens.
Ink pen.
Although
But he-
it was available.
In his cross-examination, he says that he knows his father, my lord, and the petitioner
But
also.
that this revenue becomes, you see, if it's a revenue of landlord and Jodhar under the Gwalpara Tenancy Act,
Yes.
then it is for the landlord to come and prove it.
In his cross-examination, he says, I know Procedural Abdul Kalam, father's name Abdul Kalam is Atar Rahman. That part is there, my lord. Even if my document is discarded, but his statement is there, my lord.
But he is not the owner of the land. The land revenue is not paid to the government. Normally, when you say that this is a land document and we paid land revenue, would mean that the land revenue is paid to the government. That's not so. The document loses its credibility on that account.
But some record also produced, Jodhar record as per my statement, my lord. Jodhar's record, I have brought the Jodhar's record today maintained by me. Her name of Atar Rahman is present.
No, you see, the problem lies not here. The document is produced, but who can give a better evidence? Your brother comes and says that my father is the owner of the land.
Yes.
Somebody comes and says that I have bought the Jodhar of the Jodhar records.
Yes.
That means he claims himself to the owner of the land.
Yes, ma'am.
Now, who is the owner, according to you?
Jodhar maybe will be the owner, my lord. Indian.
Jodhar will not be the owner. He will only have the occupancy right.
Okay. Yes.
And to have the, what you call, do the agriculture.
Cultivation right.
His right under the Gwalpara Tenancy Act is not transferable. Under Select Agency Act, it is transferable.
My voter list, my lord, 1966, 70 was not considered on wrong ground.
66 could not have been considered. You have seen the records.
My lord, only my lord, AS is not, my lord, eligible, my lord, but I have also obtained, my lord, again, my lord. That is there, my lord.
No, but here it is not there. The proof
Yeah.
document is not there. Please show us what you have, what you have produced, got. Let us see.
Yes, that I have seen, my lord. That is obtained mass earlier, my suppose in my 1979 or 80, my lord, that was
So
obtained.
what is the document you are having? Let us see that.
Yes, my lord. This is certified copy again I obtained, my lord. Same document, my lord. Both one is 1966, one is 1970, my lord. Only one copy, my lord. And your lordship also pass an order, my lord, to remand the matter to consider the, my lord, exhibits, my lord.
We'll have to examine because this is not the document here on record. What is there is not legible. So the tribunal.
Only, my lord,
on the basis of.
yes part, my lord. Other thing is eligible, my lord. Yes part only, my lord. 1966 voter list, yes part only, my lord.
Continue some other day.
My lord.
So that the possibly that matter could not be very strong. That. Each separate video. একটু ঘুরে দিব খবর খবর